had some interesting stuff happen this month. I got the prothonotary from the Supreme Court to issue an originating motion which was heard last Friday in the Supreme Court by Judge Robson, who, in the usual inimitable Victorian judicial officer's words, said, "I don't understand. I don't know what it is, whether it's the English language we use or the dog I had barking for me on Friday, and there's someone thinks that dog should have been shot. He's here. But we didn't get what we wanted, but by the same token, I've been to the Court of Appeal yesterday and they said, we will accept an appeal. That isn't a problem. So the process is in line to get this clarified and made clear to more and more of us. The other thing that happened was this morning I went in front of Deputy Chief Magistrate Peter Lauritzen in the Magistrates Court with 2 witnesses with me and put an injunction in front of him, and he said, "Are you asking me to exercise federal jurisdiction?" I said, "Yes." He said, "I can't do that. Case dismissed." We have now a good reason to go to either the High Court or the Federal Court of Australia with that one. So we've got, what we're looking to do is drive a wedge between state governments and their judiciary. And we can do that by having an order from a superior court back to the magistrate saying, "Do it, Charlie Brown." So, look, we're working, we're making progress, and thanks to your support and your help and your encouragement, Mr O'Brien and I are pushing on. Without any more ado, I'll hand you over to Mr O'Brien, who's got some interesting things to tell you.
Thank you, Peter. Welcome, everyone. Who's here for the first time? Okay.
It's been a long time for me to come.
Okay, we'll treat you as the first timer as well. How about that? Can everyone hear me okay? Yeah. Yeah, good.
Could you put the speaker up louder, please?
No, you're in the middle. You can hear me fine. Okay. For those who are here for the first time, Community Law Resource Group has been formed to help you, the people, to understand your constitutional rights as drafted at Federation in 1900. Now, your Commonwealth Constitution ties in with 2 other acts. You've got your Constitution here, which was passed by a referendum. You've got your Acts Interpretation Act, 1901, and you've got your Judiciary Act, 1903. Okay, these 3 form the foundation of law here in Australia, and what we show you, the people, comes out of these 3 books. And when a law is that may come out further down the line that we rely on, we check it against these 3 books. Our Attorney Generals and anyone in the executive arm of government have to check any legislation, proposed legislation that comes out of Parliament against these 3 books. Okay? If Parliament passes a law that is inconsistent with what is laid out in these 3 books, then it is to be treated as void. Void. But it doesn't exist. So we also help you here to understand how to go about telling them that it's void and standing in a position of relative safety. Predominantly, the reason we bring these meetings about is so that you can feel safe that there are a lot of others out there who are listening and taking notice of what we say. We say don't look at the messenger, look at the message. It's very important. We have lost sight of our rights as laid out by our Constitution and prior that the laws of England. The system systematically over the last 100 years has been trying to dismantle our rights. And in 1986 they basically put them way over there and they say we don't, that any legislator now is not tied to those rights, and they've created a new foundation, and that's called the Australia Act 1986. It should never have been brought in, and it failed a referendum. Okay, it failed a referendum. So we need to be aware of what power a referendum has, where you stand in the community with respect to making of laws. Okay. Now, your Constitution lays out the separation of powers. It creates what we call government. What's called government in here and what is portrayed to us are two totally different things with respect to the media and what goes on in our parliaments. Okay, that's probably if you can get your head around that, then you're well and truly on the way to understanding your rights. A government is made up of an executive, which is your Queen, your monarch, and your Governor-General and your governors of state. They are bound strictly by these three books and the laws of England. Then you've got your Parliament, which is made up of your upper and your lower house. They create the bills, the legislation, the proposals. That goes to the executive. The executive then checks it against these three and then assents to it as a law. Unfortunately, since 1986, we've now had an executive blended with the Parliament. But our checklist, that third arm of government, is very important, and it's the judiciary. It's the courts. Our courts are where we can challenge any legislation that comes out of our executive or our Parliament. It's very important we understand that. Our judiciary is in fact the most powerful arm of our government. Now, there's been a lot of people that have had a lot of problems with especially local government.
That's me.
Yeah. Okay. There was a chap up in New South Wales who wrote a letter to the Attorney General, the Honorary Robert McClelland MP. This is dated the 8th of July. His reply. Now, what he refers to here, for those who are not aware, but in 1988 there were 4 questions put in a referendum to the Australian people, and one of those questions was, do you recognise local government? In Australia, overwhelmingly 68.7% of us said no.
The establishment, the continuance, and that they be allowed to make local laws was pretty much the reason.
Now, I refer to your letter received 10 June 2010 regarding the 1988 referendum. In 1988, 4 proposals to amend the Constitution were put to voters in accordance with Section 128 of the Constitution. Now, Section 128 is where we get the power of referendum. One of those proposals sought to give constitutional recognition to local government, but the proposal was not carried. The Constitution does not currently recognise local government. Any change to the Constitution to recognise local government would need to be approved by voters at a referendum. The government will continue to explore reform, including constitutional recognition, to facilitate cooperation with local government.
I don't like those words. That last bit you just read, I don't like that bit.
But
there's a sneaky way in it. Yeah.
the thing